Can you get your green card after being deported without having to wait 10 or 20 years? Maybe you can. Let me tell you a story. We recently had a case of a client who entered the country illegally and was deported back to El Salvador. She then re-entered the country illegally on a second occasion. On the second time she came back into the United States, she married a US citizen, a man who she thought was the love of her life. Unfortunately, the marriage did not go well because she was subject to domestic violence. In this case, the client also had an outstanding expedited removal order, which meant she was not allowed to see an immigration judge and was deported back to El Salvador. Another complication in this case is that the client was pregnant when she was deported. After giving birth, the United States husband went from the United States to El Salvador to supposedly visit the child. Unfortunately, the husband ended up kidnapping the kid and bringing him to the United States, knowing that the client was subject to the permanent bar and stuck in El Salvador. In desperation, the client came back to the United States again illegally in pursuit of her child. After her third arrival in the United States, the client decided to consult an immigration attorney in an attempt to stay close to her baby. The client ended up retaining an attorney who determined that she was eligible for relief under the Violence Against Women's Act. Unfortunately, she did not obtain a great result, and she ended up hiring us. We were able to reassess her case and determine the complications that had been overlooked. Some of the complications included: 1. The client was subject to the permanent bar. Due to the several entries and deportations, this meant that the client was technically barred from coming to the United States forever and even have to wait 10 years before seeking admission to the United States. And 2. The client was subject to an expedited removal order. No hearing before an immigration judge. ICE could deport her at any second due to this expedited removal order. And 3, she opened up herself to yet another inadmissibility ground of smuggling since she had brought her oldest child with her on that third occasion. In the end, we were able to navigate through these complications, submit her green card application, 2 different waiver applications, and at the mercy of ICE, begged that she would not have her expedited removal order reinstated. All of this so that she not only had a lawful status in the United States, but remained next to her children. Today, she's a green card holder. My name is Ana Gracia. I'm an immigration attorney here at the law offices of Jessica and Moist, and if there are any questions, any situations, any complicated matters, please reach out to us.